Hello, this is Alexander Cross, Criminal Defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. So, we received an interesting inquiry here on our YouTube channel. This has to do with being accused of selling drugs. Let's see here. The police came to my house and took my phone. They found messages saying to take the cargo to the indicated place. I didn't know everything they told me in those messages, and I never replied to the messages. Now I have a court hearing. Well, just because you didn't reply to them doesn't mean that they didn't necessarily apply to you. If there's other evidence indicating that you may have been involved in this conspiracy to possess, control, obviously, distribute controlled substances, well, then you're going to be part of the whole conspiracy. Remember that possession of controlled substance for sale is a felony here in the state of California under Health and Safety Code 11351, which carries up to 4 years in state prison. Transport of controlled substance with the intent to sale is also a felony under Health and Safety Code 11352, which carries up to 5 years in state prison. And of course, if you are accused of being part of a conspiracy to commit such an offense, any crime that other people commit in furtherance of this conspiracy together with the plan could also get attributed to you. And just for your knowledge, conspiracy in and of itself, conspiracy to commit a crime in and of itself is a felony under Penal Code Section 182, which carries also up to 3 years in state prison. In this case, it'd be best if your attorney went to court, entered pleas of not guilty, ordered copies of all the evidence, and then took a lot of time to study all of it in order to determine the level of credibility of the evidence. It's very possible that a private investigator is going to have to get involved to potentially talk to other witnesses, other people involved, to see if there are any inconsistent statements that can be extracted. But eventually, the evidence is going to have to be decided upon, studied, and a determination is going to have to be made whether or not there's credibility against you or if there's no credibility. If it looks like there's no way a DA could convince a jury that you were actually involved in this, it may be worth taking this case to a jury trial. But if it looks like there's a good possibility that you're going to be convicted, at that point you might want to have your attorney discuss the matter with the DA to see if a plea agreement could be reached. Regardless, if you'd like to learn more about criminal defense here in the San Francisco Bay Area, don't forget to subscribe to our channel, Law Offices of Cross & Associates, and feel free to ask questions in the comment section below so that we may respond in the future with more videos for you. But if you've been accused of a crime here in the San Francisco Bay Area and need representation, call us now for a free consultation at 1-800-862-7677. Once again, 1-800-862-7677. Criminal lawyer, criminal lawyers, DUI lawyer, DUI lawyers. Criminal attorney, criminal attorneys, DUI attorney, DUI attorneys.